Can you mention?
Your Lordship, I beg to mention item number 9, Your Lordship. Kindly let this matter come after 2 weeks. Item number 9.
Item number
We
9.
have to file a written argument, Your Lordship.
That is pending for only submission of.
Written argument.
Yes.
We need some
Why you
time.
taking too long?
2 weeks, Your Lordship.
I'm preparing by London Council for the petitioner for the 2 weeks. Time is granted for submission of written notes of argument.
May it please, Your Lordship. Your Lordship, I beg to make a mention of item number 10, Your Lordship.
Yes.
Lordship, I pray for 2 weeks' time, Your Lordship.
Why?
I'm for respondent numbers 4 and 5, ma'am.
No objection.
No objection.
Prayer of the petitioner, not objected to the London Council of the respondents. List after 2 weeks. Yes.
Should I beg to mention item number 16? This matter may kindly be taken up after a week, madam.
After a week.
Yes, ma'am. Subject to your lordship's convenience. Much appreciated.
On the prayer of the petitioner. List after a week. Yes.
May I please, Your Lordship, I beg to mention item number 11, Lordship.
Yes.
Due to personal difficulties, Lordship, up to 2 weeks, Lordship.
No objection.
The prayer of the petitioner, not objected to the London Council of the respondent. List after 2 weeks. Yes.
Similar prayer for item number 17 also, Lordship. After 2 weeks,
The
Lordship.
connected matters pending before deviation. No objection.
It's pending your division bench.
Yes,
Yes,
Lordship.
Lordship.
I'm for the private.
Yes. Just make it 3 weeks on the prayer of the petitioner. 17. Yes.
Highly request, Lordship.
May it please Your Lordship, I beg to mention item number 18. Your Lordship, I'm praying for 2 weeks' time.
No, sir. This is a POXO matter.
Yes, Your Lordship.
This also. 2 weeks. 2 weeks
Yes, Your
for the
Lordship.
request of the appellant. Yes.
Much obliged, Your Lordship.
Supplementary cost list, item number 1.
Yes, Mr. Yuvan.
My lord, my lord, I was appointed, my lord, as a constable in the Meghalaya police, my lord, with effect from 1st of June 1978, my lord. 1st of June 1978. I've served for about 30 years unblemished. Now in the year 2003, illness...
2003, not 30 years, 25 years.
25 years, my lord. My lord, illness struck. So because of which illness, my lord, some illness and ailment, health issues crop up, 2003. Because of which, my lord, I was having lots of problem attending. And I even got medical leaves, my lord, rest and all this thing, my lord. Having understood that I'll not be able to continue in the force, my lord, I have submitted an application requesting to allow me to go on VRS, my lord. Now that VRS, my lord, was not answered, was never answered. As per the rules, my lord, 3 months if you don't answer, if you sit over the applications and it is assumed that is accepted. But now, my lord, what happened was that then pending VRS, my lord, there was a departmental proceeding going on against me. There was a departmental proceeding.
In 2003.
2000, yes, my lord, 2003, no, 2005 onwards, my lord.
That proceeding was done before you submitted your application for VRS.
No, after. So, and my lord, there was no presenting officer appointed in the departmental proceedings. There was a complete violation of the principle of natural justice also, my lord. And now, my lord, by the order 22nd October 2007, my lord, I was discharged from the service, my lord. I was terminated, so to say, my lord. Now, my lord, as I said, my lord, out of distress, financial conditions, illness, my lord.
What was the allegation in the departmental proceeding?
Departmental proceeding is, my lord, absence without leave, my lord. Absence without leave. Now, the question of proportionality also will come, but anyway, I'll just for the sake of motions today, my lord, because there's no stay applications at all, and it can't be also now. Now, my lord, because of distress and financial difficulties, and I am during 1978, my lord will know, Assam. I'm a Garo person from Assam, my lord, Golpara. So, going back to the villages and all without legal remedies, I mean, not aware of the legal availability, my lord. There was substantial time passed. Then finally, my lord, I have filed one appeal memo. I filed an appeal requesting for reconsiderations because I have already submitted my VRS applications, and subsequently I was discharged, my lord. These applications, my lord, was and along with that, I have also filed a condonation application before the appellate authority. The appellate authority is
You
a
challenged your dismissal from service.
yes.
Your dismissal was in 2000,
2007, my lord. 2007.
and then when did you challenge your?
And in the year 2024, my lord. 2024. I've
17 years.
After 17 years, of course, my lord, I've challenged that. So, my lord, I filed an appeal before the Director General of Police, my lord. And along with the appeal, my lord.
Rule stipulate some.
Yes, it's 3 months, right? 3 months, my lord.
And is there any provision for condonation of that 3 months?
My lord,
In the rule.
the rule is silent, my lord. The rule is silent on.
You see, if there is no provision, that means there is nothing. It is.
My lord, there is no
Provision for condonation.
there's no provision for condonation, but there are rules, my lord, which says that's because, as I've said, as my lord has rightly corrected, that 25 years of service, unblemished service, I've completed. Till the time I have submitted my VRS, and till the time 2007, my lord, when they have passed the impugned order of termination, my lord. And the rules also says, my lord, 38A of the Meghalaya Acts and the service pension rules also said, retirement on completion of 25 years continuous qualifying services, my lord. There are also provisions, my lord, which entitles me for this. But anyway, my lord, the delay application, my lord, was...
You filed your application for VRS
Yes.
in 2003.
2003.
And you are assailing non-consideration after 22 years.
My lord, here, actually, my lord, if we'll just go back a little, my lord, I know it's coming a very difficult case, I know, but for me, my lord, now, but delay, my lord, along with the delay applications I filed, my lord, and I try to show a sufficient cause, my lord, that the sufficient cause was distress and financial constraint, my lord. Sufficient. Now, there was an impugned order. After that, my lord, there was an impugned order passed by the DG. The impugned order is here, my lord, which I am challenging today, my lord, is at 108, page 108, my lord. Page 108.
Yes.
May I just read this impugned order, my lord? Whereas in the year 2002, Shri so-and-so had availed leave on medical ground with effect from such and such, but failed to report back duty thereafter. A report of unauthorized absence was submitted by officer in charge Mendi Pathar in 2002. Whereas a disciplinary authority, in adherence to the principles of natural justice, had provided ample opportunities to explain his absence and to report back to duty by issuing of several notices and explanation calls, however, failed to respond or resume his duty. Whereas it is evident that despite repeated directives issued 2002-2003, including notices, explanations, so and so, the ex-UBC willfully remained absent and absconded from duty without authorization, thereby violating the service conduct rules and norms. Whereas the disciplinary authority, on careful examination of the explanation and reply to show cause notice
So
submitted,
even we'll just see, yes,
my lord,
we'll use
And-
notice.
Lordship.
my lord, because even the leave gratuity, these are also not paid, my lord. second part of the prayers are also there.
If you are dismissed for service, do you have a claim for the things? Whether those claim for those benefits will be maintained, until and unless your dismissal is interfered with.
My lord, my lord,
So that will be dependent upon what we decide.
my
here.
lord. Yes, my lord.
Heard, Mr. Yugen, counsel the petitioner. Notice written within 3 weeks. MSNG Shilla learned additional learned senior GA. APS for all the
All respondents, Lordship.
okay. That's it. The next for justice, the learned senior GA shall obtain necessary instruction. List after 3 weeks.
Much
My
obliged, Lordship.
obliged.
Delay is one thing.
Delay is, my lord, delay will defeat, but my lord,
Who knows, the third party right might have accrued. Your position which you vacated,
yes,
if
my
it
lord.
is filled up, then what happens?
Yes. But the question, there's one very interesting question that emanates, my lord. Once you have submitted VRS and 3 months gap, that waiting gap is there, and after that is assumed to be, and subsequently you terminate me, terminate me.
That would be dependent
Yes.
on the departmental allegation on you.
Yes,
Whether
yes, my lord.
at the time when you submitted, whether there was any allegation pending.
Allegations or not, my lord. Yes.
We'll see it after
Yeah,
reply
my lord.
comes.
Obliged,
Obliged.
Lordship.
Item number 2.
There is, okay. We have any part 1 matter in item main list? The order matters. We call this order matters first, then we'll come to. Yes, Mr. Dev, just wait, we'll just finish those other part 1 matter, then.
Obliged.
Daily list. Item number 1.
Lordship, pursuant to the last order, we have taken steps in this case
Yes.
for condition of delay. I am yet to, Lordship, obtain the confirmation from the postal department. Single
But then
respondent,
ID card has been received.
Lordship. Perhaps we can wait for their appearance, Lordship.
There is no one appearing. Okay, the official note indicates that there is only one respondent.
Single respondent, Lordship.
The official note indicates that the notice upon the respondent number, upon the sole respondent has been effected. Stop. However, there is no appearance on behalf of the respondent when the matter is called out.
It may be listed after
Is straightforward with the learned counsel of petitioner. Dismissed after 2 weeks
2 weeks, Lordship, to enable the appearance of
to await appearance of respondent number 2.
Lordship. Much obliged.
Item number 2.
Or rather make it to enable appearance. Yes.
My lord, I'm appearing on behalf of Mr. P.R. Paske.
Yes.
Kindly list this for admission hearing, my lord.
This is a revision
This
application.
is a civil revision petition, Your Lordship.
Why you are challenging the maintainability?
Yes, my lord.
On what ground?
My lord, I'm under limited instructions.
Yes.
Lordship, it may be fixed, Your Lordship.
For admission hearing
Lordship.
or for admission? Admission. Okay. Yes, on prayer made by learned counsel appearing for the parties. This is a matter for admission. When?
Uh,
After?
two,
After 2 weeks.
2 weeks, my lord.
Yes.
Much obliged.
Item number 3.
May it please, Lordship.
Yes.
Lordship, this is a prayer for quashing of FIR and subsequent proceeding, Lordship. Matter involves motor accidents, Lordship. One scooty and car were involved, Lordship. The parties have settled the differences, Lordship.
What about the rest of 4 and 5?
Lordship, we have served, and I think my friend is appearing, Lordship.
Okay. You have objection to that? No, yes. What about state?
Your Lordship, it is a non-compoundable offence, Your Lordship.
That is why they are here. Otherwise
Yes,
they
Your
would have
Lordship.
been-
And moreover, Your Lordship, there's no medical report of the victim. So the injury, whether it was grievance or it was a minor injury also, that cannot be determined. So,
Lordship, my humble prayer is, Lordship, the victim was hospitalized, Lordship, and all the charges were borne by the
There are
petitioner,
decision
Lordship,
by
and
this court.
he has subsequently been discharged.
There are decisions by this court.
yes, Your Lordship.
Similar kind of
We are
matter.
covered by that
You
decision.
have those decisions with you.
Lordship, I'll bring it on the next occasion, Lordship.
So we'll just list it for hearing then. We'll just record our appearance. Yes. Just say MS. Since the Learned Council has entered appearance on the restaurant number 4 and 5. Stop. Hence the service is complete. As per to the parties, list this matter for hearing after 2 weeks.
2 weeks, Lordship. Obliged, Lordship.
Obliged, Lordship.
Yes.
May I please, Your Lordship? As per the last order, we took steps for respondent number 4, Lordship.
May it please, Your Lordship. Your Lordship, I'm entering appearance on behalf of the respondent number 4, Lordship.
Yes. Who is this? One number 4?
Oh, no, that is the school, my lord, represented by the principal.
So you'll be filing your affidavit.
Yes, Your Lordship.
Okay. So service is complete. MSI Lingual Learned Council, not Learned G. Has entered appearance, we have the restaurant number 4. Step. Service is complete. State also will be filing affidavit?
My lord, we have already filed our affidavit. In fact, they have prayed for rejoinder on the last occasion also.
Yes. Yes. This has already been. So you want to file a rejoinder against
Yes,
state
Lordship.
affidavit of the.
Yes.
You are there for Mr. Pala? Yes.
Pala is with for the state, my lord. We are appearing together, my
You are
lord.
there together. Okay. Just say so much service is complete. Go on preempted by the Learned Council for the restaurant number 4. 2 weeks time is granted for filing affidavit of opposition. Stop. In the meantime, it will also be open for the petitioner to file her rejoinder to the affidavit of opposition of the state respondent. List after 2 weeks.
As your pleasure.
Item number 6.
Your Lordship, they're supposed
Your
to pass.
Lordship, I need some more time to file the affidavit.
Counter affidavit.
Yes, Lordship.
Yes, Your Lordship.
You are representing all the respondents.
Yes, Your Lordship.
Is that correct? You are representing all the respondents.
No, Your Lordship.
Then
Yes.
yes, Mr.
Yes, we have all for the respondent.
Lordship, yes, it's a service matter.
Okay. One prayer made by MS so Learned Council appearing for the respondents. How much time?
2 weeks, Your Lordship.
Further 2 weeks time is granted for filing affidavit of opposition in the matter. Yes.
7.
Please, Lordship.
Yes.
Lordship, we are still awaiting instruction in this matter.
You are appearing for the state?
No, Lordship, for the MEC corporation.
Okay.
No objection. Okay.
One prayer made by
Kindly allow 3 weeks time, Lordship. 3 weeks.
Permitted by Ms. Sir, Learned Counsel appearing for the. You are appearing for all the respondents.
Lordship.
Appearing for the respondents. 3 weeks time is granted for filing. Affidavit.
Motion.
Yes.
Item number 8.
The
Yes.
gratuity and leave salary, Lordship. He's a retired
Okay,
salary,
affidavit.
Lordship. Yes, Lordship.
Yes. District Council.
District Council, Lordship.
GHDCO, yes. Affidavit.
Gratuity and leave salary, they used to grant, give only leave salary and gratuity, Lordship. That has already been sanctioned, but they are not paying, Lordship. That is the.
No, that is so, but then affidavit has not.
No,
come.
not yet, Lordship. Not yet, Lordship.
Lordship, we need some more time. We need some more time.
Same order on prayer made by so-and-so, Learned Counsel and the respondents. How much time?
2 weeks.
2 weeks time is granted for filing.
Mas.
Yes.
Supplementary cost list. Item number 2.
Yes.
Lordship, I filed the additional affidavit bringing on record the charge sheet. And in the charge sheet also, Lordship, the entire charge sheet has been filed.
Can you just tell us, take the facts first, then you come to all those things. Just tell us the story first, the facts of the case.
Lordship, criminal petition 50. Lordship, the brief fact, Lordship, what had happened is, if Lordship is pleased to come to page 19 of the petition, annexure 1.
Yes.
Lordship, this is the passport or a travel document issued by the United Kingdom of Great Britain and Northern Ireland to the petitioner. Now, admittedly, Lordship, this is valid and
Decision list.
19,
Parallel 19.
page 19
Sorry, page
of the
19
petition,
is-
of the petition. I'm sorry, of the petition. So this is the Lordship, this is the travel
Oh, you are a
document.
citizen of United Kingdom.
Lordship, yes. And how I have got this document is, Lordship, I was originally a national of Bangladesh. And due to certain political turmoil, under the convention, Lordship, this is the 1951 Refugee Convention, where India is also a party. This has been issued, Lordship, to me by the UK government as a political refugee. And the only condition, Lordship, is that I am not allowed to go to Bangladesh. I can travel the world except Bangladesh. Because there, Lordship, there is a threat to my life. Now, with this passport, Lordship will kindly see at page 20. Lordship, this is the visa issued by the Republic of India to the petitioner.
Page 20.
Page 20, annexure 2, this is the visa, Lordship. There is also no dispute, Lordship, that with this visa is a valid visa issued to the petitioner by the competent authority.
Okay.
And Lordship will see the stamp marked on the visa. It says Immigration Center, New Delhi. Why I am pointing it out, Lordship, that I had entered India through the international airport at New Delhi, through the immigration check gate itself. It was not a case of illegal entry at that time. Now, thereafter, Lordship, in due course of my
When did you enter?
25th March. Visa issued on 12th March, I entered on 25th March, Lordship. Set to expire on 11/9.
Where it is stated? Is it stated in the petition?
Lord, in the annexure itself, it is mentioned, Lordship. Kindly see page 20. Lordship, it's a surname and name given, Uddin Mehtab. Below that, passport number, which is the
Not
previous
that
one.
legible, Mr.
Lordship,
You know
I
things.
understand, Lordship. This because to type this, I
Have you not mentioned it in your petition?
Lord, I have. Yes, Lordship, may kindly bear with me. Lordship, I have mentioned only the date of expiry.
It is valid till 27/11.
Lordship is valid till 11/9/25.
When was the visa
Visa issued on the left side, just below on top of the photo, Lordship, at page 20, 12/3/25.
There will be a gap of how many?
12/3/25 date of issue, date of expiry on the other side, 11/9/25. And I entered
The expiry is,
11/09.
but then here your what is this validity of the passport?
Passport is till 2027. Passport is till 2027. Visa I have got for 6 months as per the procedure, Lordship.
Okay.
Now, in the course of my stay in India, Lordship, on 2nd of July, an FIR has been lodged against me by the COI commander of BSF, Lordship, stating that on 1st of July, at around 10:30 at night, I was apprehended and they have forwarded me to the police. Apprehended from Dowki Market.
Where is the FIR?
FIR at page 21, Lordship. Next page.
Yes.
Lordship, it essentially says, Lordship, that on 1st July 2025 at about 10:30 on the specific information of Unit G Cell Patrolling Party of BOP Dowki consisting of so-and-so, and 01 OR total 5 personnel apprehended 2 UK nationals suspected to be Bangladeshi nationals in Dowki market area. During preliminary questioning, the BD, the Bangladeshi national, revealed their name as so-and-so and two so-and-so. Both were in possession of UK passport. And during preliminary questioning, they revealed that they came to India for visit purpose only and further illegally crossed over to Bangladesh to meet their family. BSF party apprehended them when they crossed over to India from Bangladesh and were in search for transportation from Dowki to Shillong. So the allegation, Lordship, is that I have illegally crossed over to Bangladesh and re-entered India, and I was at Dowki market where they apprehended.
After you entered
Lordship.
India, the territory of India,
Lordship.
your movement was not restricted.
No, I had a valid visa.
That is okay. Even after valid passport also, you may not enter.
Canton, like military areas.
There are some restricted areas.
Correct, Lordship. Absolutely. So here
So you did not have any such stipulation was not there.
That was not an issue at all.
You are not supposed to visit Dowki or this thing.
There was no such issue at all. The entire issue was that I have illegally crossed to Bangladesh and come back to India.
Okay.
And while I was searching for a cab from Dowki to Shillong, I was caught in the market.
You are caught in the market.
Lordship. Apprehended in Dowki market area.
Then if you are caught in the market, how could they say that you tried to...
That is the whole point, Lordship. What I am trying to say is that this allegation that I entered India with a valid visa, went to Bangladesh illegally and crossed back to India is entirely, Lordship, unsubstantiated.
It is without any basis.
In the air, Lordship, yes.
It is without any basis.
Lordship, yes. The fact remains I have not been apprehended anywhere near the border from the market itself, well within Indian territory. Okay. Now, Lordship, the FIR has been since registered.
But then see the last line
Lordship.
of the same FIR, same paragraph.
Lordship. When they crossed over to India
The party apprehended them when they crossed over to India from Bangladesh.
Lordship. So this would mean, if Lordship is seeing only this line, it would mean that perhaps they apprehended me while I was trying to cross. But that is not the fact. Fact is in that very FIR itself, Lordship, that I was apprehended from market area.
Anyway, it's okay.
Now, Lordship, seizures have been made from me. My passport and everything has been seized.
Nothing illegal recovered from you.
I don't see anything.
Whether is there an allegation something illegal recovered from
Lordship may see the recovered
that is
items.
okay. If it is not there, just go by the allegation now.
Passport, permit, currency, mobile phone and personal belongings.
You are found with some other person, another person,
That's why there are two petitioners, Lordship.
in the same petition,
No, in the other
different
in the second matter, yes.
same cause of action,
Same cause of action, same FIR, same charge.
everything same.
Everything same. Allegation also same.
There also the visa validity, everything is same.
Only in the second item, the visa is expiring in December, not in September. That is the only difference.
Okay. Yes.
Now, Lordship will kindly see that thereafter I was forwarded to the Honorable Court and kindly see the seizure list just to point out that nothing illegal was seized from me, Lordship.
Yes. If there is no allegation that
Yes.
something.
And that is not the allegation also that I have
Yes, that is what.
having something from there. So thereafter, Lordship, the matter was filed before the court at Amlarem, before the judicial magistrate under 14A, and a charge sheet has been filed under 14A, Lordship, that I have brought on record by way of an additional affidavit.
Okay. You were arrested.
I was
and then
arrested,
released on bail.
and that bail order I have enclosed, Lordship.
Okay, all right.
That is
Anyway, that has been.
yes.
Whether order will have any bearing in this matter?
Order I don't see, Lordship, because I have been released on bail.
Okay. Then.
But only what I wanted to point out from the bail order, Lordship,
Yes.
is that although it is not very specifically reflected, what is reflected is the IO had no objection, or IO said that he does not require my custody. And why that happened is that, Lordship, on the first day of moving the bail, the learned trial court directed for the IO to verify my passport and visa.
He said you are no longer required.
Correct.
He did not say you are not at all needed.
No, he did not say that I am not guilty. But what I mean to say is that before I was granted bail, my passport and visa were found to be duly verified and found to be proper. That is the only point, Lordship. Now thereafter, Lordship, the charge sheet has also been filed by the state, by the IO. I have put it on by way of an additional affidavit, Lordship.
Yes.
Lordship may kindly have page 6 of that affidavit.
Yes.
Lordship will kindly see point 4, Act, Foreigners Act 14A.
Yes.
And now, Lordship may kindly see the allegation in the charge sheet. By the same charge sheet, both the people have been charge sheeted.
So there is a common.
It's a common charge sheet, Lordship.
Yes.
Now, kindly see page 13, the brief facts of the prosecution's case.
Page 13.
13, Lordship. It's in the other affidavit.
Yes.
And in the other one, sir. In 51. I'm sorry, Lordship. So, page 13, this is the charge sheet. If I may quickly read it, Lordship. The prosecution's case is that on 2/7/25 at 5:50 p.m., written FIR received from Shri So-and-so, COI Commander, ECOI BOP Dauki, 4th Battalion BSF, to the effect that on 1/7/25 at around 10:30 on specific information. So, this is, Lordship, essentially a reproduction of the FIR. Now, kindly see, Lordship, the third paragraph. During the course of investigation, the below noted arrested persons were interrogated thoroughly at Dauki PS, and it was ascertained that they are of Bangladeshi national and had managed to procure UK travel document after they were staying in United Kingdom for some period of time on the ground being threat in their life at Bangladesh and take the asylum. They arrived in India with UK, United Kingdom of Great Britain and Northern Ireland travel document and with proper visa. And from India, they crossed over to Bangladesh illegally through unfenced border, and on 1/7/25, they crossed over to India illegally through unfenced border with the intention to go back to UK after meeting their families in Bangladesh. However, they were apprehended by the BSF on duty after receiving a specific information about their movement. The travel documents of the arrested Bangladeshi nationals are as follows, such and such. And, Lordship, based on the above facts and circumstances, it is found that the prima facie case under 14A of the Foreigners Act is well established against the arrested accused persons mentioned below for crossing over to India from Bangladesh illegally through the unfenced international border. So that is a specific allegation which they have made.
Yes.
And Lordship will see at the bottom what is enclosed in the charge sheet.
So your nationality is not questioned here. It's like,
No.
yes.
What has been
The
enclosed?
offence alleged is that you have crossed over to India from Bangladesh illegally.
That is the only offence, Lordship. Kindly see what has been enclosed to substantiate this charge, Lordship. Statement of Mehtabuddin, he is the accused.
Yes.
Statement of Ziaur Rahman, he is the co-accused.
Yes.
Certificate under 63, this is regarding the electronic record, the phone and all that. Seizure list. Then photocopy of national ID card of Bangladesh, Bangladesh passport, and photocopy of the birth and photographs of the accused. And Lordship will see it appears, Lordship, that the entire basis of the charge sheet is an allegation which is completely unsubstantiated, and how they want to charge me on this offence is on my own statement, Lordship, recorded under.
What are all those other documents?
Lordship, I have enclosed all. Lordship may kindly see page 15.
No, that is all. See this the list. Just see, go through the list. Photocopy of national ID card.
Lordship, this is those passport and the all those ID cards, Lordship.
No, what about your copies of your UK's passport?
No, not seized. Not seized, but somehow it is kept with the IO till date. But not formally seized in the charge sheet. Or not mentioned in the charge sheet. But they were seized. That Lordship will see in the FIR itself. In the box they mentioned that these articles were seized. But somehow it is not mentioned in the charge sheet.
That has not been seized.
So what I am trying to submit.
The FIR, it is mentioned, isn't it?
Lordship, even seizure list is there. But why it is not mentioned in the charge sheet, I don't.
Where is the seizure list?
Lordship, seizure list is there. Kindly have page 19.
Page 19 of this?
Of this affidavit itself. So I feel perhaps they have not, because they have enclosed the charge sheet, this seized. Number one is the UK, this one, Lordship.
Okay. Travel document. Yes.
Lordship, UK document, travel document, driving license, residential permit, some currency, and phone and personal belongings.
But then this is not cited as a list of documents.
Only the seizure list itself is cited.
Is it?
The seizure list is cited.
Where is that?
At page 14 only, Lordship. Point 5, 6 and 7.
This refers to
the seizure list at page 20, page 19, Lordship. 19,
Yes.
Lordship, is MR 72. This refers to point 5.
How do you know that?
It's written on top, Lordship. It has somehow been covered by the seal of the magistrate, but it is written very vaguely.
Okay, MR number so and so. 19 is the
19
serial
is
number?
the seizure list.
Serial number?
Serial number 5.
5.
Seizure list MR number 72.
That is in respect of the petitioner here.
Yes, but the other documents which were seized, the national ID card, Bangladeshi passport, and all, those have been separately mentioned, but nevertheless, Lordship.
That's all right.
So what I am trying to humbly submit, Lordship, is that the first thing is in this charge sheet, what is the material that the investigating authority has collected against me to form this charge is not there, Lordship. There is no material apart from my own statement. And in what circumstances my statement has been put, Lordship, that is completely wholly inadmissible, Lordship. I cannot be asked to I cannot be compelled to witness against my own self for the purpose of the police to file a charge sheet, Lordship. That too in a very serious offence of Foreigners Act 14A. And what I am saying is, Lordship, that for them to say that the entire burden lies on me.
In the trial of Foreigners Act, in a trial,
Lordship,
CRPC applies.
CRPC applies.
So provision of 162 also will apply.
Definitely, Lordship.
And that same thing that, what is that, Evidence Act section 20, what is that, 25, 26, 27, what is that?
Section 25.
25, Lordship,
The
yes.
statement made before the police officer.
Police officer is wholly
There is a
inadmissible.
bar,
Yes.
isn't it?
And in fact, the accused statement, even for the purpose of corroboration and all, also is very limited, unlike the witnesses' statements of 161, Lordship. So, what I'm trying to
Say
say,
it again, please say.
what I'm saying is, Lordship,
No, no, what did you say?
statements of the complainant and other witnesses under 161 can be used for the limited purposes of corroboration and contradiction.
Exactly.
But the accused statement, Lordship, they cannot use it to corroborate or contradict my own defense in the trial. So what I'm saying is that my 161 statement, or this is recorded,
Because you are not a witness to the trial.
Lordship, and this is under, of course, under 180 BNSS, but the same principle
Then
applies.
what happens, say supposing if you offer yourself as a witness after 313, whether 161 can be used?
No, if I would have given a confession before the magistrate, they can very well use it.
Not a question of
But
confession.
there also, yes.
Not a question of confession.
Lordship.
So far as your submission with regard to the statement, your statement under 161 is concerned, you say that statement under 161 can be used to corroborate or contradict.
Lordship.
Rather, not corroboration, rather contradict.
Contradiction.
Contradict the evidence of the witnesses.
Lordship.
Meaning thereby prosecution witnesses.
Lordship.
The accused will not be never be a prosecution witnesses.
Lordship,
So
yes.
161 cannot be used.
Lordship.
That is your submission.
Lordship, for the purpose of confronting him.
You say supposing it's after 313,
Lordship.
when you adduce defense witness,
Lordship.
you are examined as a defense witness.
As a defense witness.
You offer yourself as a defense witness.
Lordship.
Now, what would be the position of law? Whether 161 statement can be used to contradict you?
Yes.
It can be.
Yes.
So that means your first part of the submission is not correct. Then.
No, I am saying for the prosecution story. That would be for contradicting my own defense, Lordship.
So it is not totally excluded.
Not totally excluded, but prosecution cannot gain any benefit out of it, Lordship. That is only what I am saying.
They gain once you. They gain.
If I
once you
contradict,
offer
of
this.
course, yes.
They may.
Yes. So my humble submission is, Lordship, that for the authorities to simply allege that some person having a valid UK visa, having a valid Indian visa, having a valid passport, picked up well within Indian territory, simply to allege, Lordship, that they have crossed through the unfenced border without any material at all to substantiate their allegation, Lordship. In my humble submission, the basic foundational facts.
What is the language of section 14?
Lordship.
Foreigners Act.
I put a Lordship. Before your Lordship comes to section 14,
Yes.
if I may just take your Lordship to section 9, because the entire burden,
Proof is on you.
Lordship, that is what I want to distinguish. Kindly see section 9, Lordship.
Yes, please.
If in any case not falling under section 8, section 8 is when a person may have more than one nationality, so that is not the case here. Any question arises with reference to this act or any order made or direction given thereunder, whether any person is or is not a foreigner of a particular class or description. The onus that such person is not a foreigner or is not a foreigner of such particular class or description, as the case may be, shall notwithstanding anything contained in the Indian Evidence Act lie upon the such person. So what I want to impress upon your Lordship is that the burden of proof under section 9 for the Foreigners Act is not a presumption of committing an offence. It is a presumption of a person being a foreigner. Only confined to that issue, Lordship, that whether a person is a foreigner or not. But this burden under section 9 cannot be used by the state.
One minute.
Lordship.
No, there is no dispute. You are a foreigner. You are a foreigner.
So what?
The question is about the legality of your entry into the.
Correct. 14A. So what I am trying to say is that an allegation under 14A directly the burden does not come under me by virtue of Section 9, Lordship. It is for the state to prove the basic foundational facts.
No, whenever the question of your nationality is not in dispute here.
Not disputed in this case.
Isn't it?
Lordship, yes.
Only it is only about your entry in the country.
Entry.
So I would say whether it's an illegal act
Lordship, yes.
under the Foreigners Act or not, it comes under foreign or not, that is why.
Lordship, yes. So it is not a question of Section 9 burden which I am not able to tide over. Because admittedly there is no dispute that that I am a foreigner. So now Lordship may kindly see Section 14A. Penalty for entry into restricted areas, etc.
Section 14A.
Capital A.
Wait. Yes.
Lordship may kindly see clause B. Whoever B enters into or stays in any area in India without the valid
Your
documents.
allegation is under what? Section 4A?
They have
Acha,
mentioned
both and
14A.
A and B will be inclusive. Okay.
Yes, I feel Lordship it would be under B as per their allegation.
What A says?
A says Lordship enters into the restricted area without obtaining permit from the central government and so on, Lordship.
So that is
not the
your entry
allegation,
is not
yes.
into a restricted
That is
area.
not the allegation. Allegation is I have entered illegally into India, so that would perhaps fall under B, Lordship. Enters into or stays into any area in India without the valid document required for such entry or such stay, as the case may be, under the provisions of any order made under this Act or any direction given in pursuance thereof. So, Lordship, what I am trying to say is that for this section to be invoked,
Say supposing you hold a passport
Lordship,
from UK and you enter via Bangladesh, then what happens?
I could not have entered through Bangladesh, Lordship, with that UK passport.
That is so far as your case is concerned.
Lordship.
Just take for a general thing. Say supposing you have free entry in Bangladesh also. You have a passport
Lordship,
and you come out for travel purpose
Lordship,
and you enter India through Bangladesh
Lordship.
and you are a holder of UK passport. Will it be illegal?
Lordship, what I am saying is once a visa has been issued to me for entering into India, that usually the visa talks about the entry point and the exit point.
Okay.
So I could not have taken that visa, gone through Bangladesh or some other country and entered India through that visa. I would have
So
had,
that will be an illegality.
that would have been an illegality.
Yes.
But here the case is not that I have not, I have obtained the visa, entered through the Delhi immigration
Yes.
checkpoint only, Lordship. So what my humble submission is, Lordship, that Section 14A essentially prosecutes infiltrators, if I may put it that way, Lordship, who enter into India without any document, any valid document.
Yes.
Now, assuming, Lordship, assuming that I had a condition in my visa which was validly issued, some condition which prohibited me to do a certain act, and that condition has been violated, assuming, Lordship, in my humble submission, that is not a violation under 14A. If at all, that is a violation under 14 small b, Lordship. Lordship may kindly have it. Section 14B. This talks about visa violations, Lordship.
No, but then where is the violation here?
Remains in an area for a period.
Does any act in violation of the conditions of the valid visa?
Conditions of the visa.
Now, what is the conditions stipulated in your visa?
Only not to enter. Visa did not have a condition, Lordship. Visa was
That
a.
means if there is no condition, that means your entry was unrestricted. Violation of the conditions of the valid visa.
Lordship.
So it must be to say that you have violated some condition. There must be some condition in the visa,
Lordship,
isn't it?
In certain, usually the conditions are, Lordship, those general
Prosecution case is not that you have
violated the condition, yes.
So why you say that it can be at the best?
No, I am saying that considering that admittedly I had a valid visa, in the event I used or misutilized that visa, that would amount to a violation of my visa.
Violation of visa will come when you violate a condition
Lordship, yes.
stipulated there,
Yes.
isn't it? So far as you are concerned, no violation.
That's why I said assuming, Lordship. Assuming in the event there was a condition which I violated by entering, going to Bangladesh and coming back. Before that, I want to submit, Lordship, assuming I went to Bangladesh and came back. Lordship, some material has to be there from the prosecution's side to show even remotely that this is a substantiated allegation, Lordship. Otherwise, on what basis, Lordship, I have been prosecuted? And Lordship may kindly appreciate that to implicate someone under the 14A of the Foreigners Act or any other provision of the foreign, this has a lot of castigating effect to the life and liberty of the individual concerned, Lordship. And he may be a foreigner, he may not have certain fundamental rights, Lordship, but rights under 14, 21 and 20 of the Constitution is very much there for all individuals, Lordship. So what I'm humbly submitting, Lordship, that what has essentially happened is that they have simply picked me up from the market on the suspicion that I am a Bangladeshi national, which is also not correct. I am not a Bangladeshi national, Lordship. I was at one point of time. And without any material to show that I have gone to Bangladesh or crossed over back from Bangladesh to India, they have filed this charge sheet against me, which is essentially nothing but a reproduction of the FIR, Lordship. And there is nothing in the charge sheet from which I can, as the accused, can see, Lordship, that what is the material forming the basis of this charge. My own statement, Lordship, by itself cannot be, Lordship, the sole basis to charge me under this kind of an offence. Especially when, Lordship, the burden of proof, as I stated, burden of proof to prove entry, illegal entry.
What is your own statement? Where is this? Is it available here?
That is there in the charge sheet itself. Kindly see, Lordship, my statement at page 15 of the additional affidavit.
Yes.
15 and 16, two statements.
Of two accused, isn't it?
Lordship. Very identical.
Yes.
Lordship, if I may read, page 15.
Yes.
I examined the accused person at Dowki PS on 2nd July and he voluntarily stated that my name is as stated above. I am a Bangladeshi national and I moved to UK since 2016 with a proper passport of Bangladesh, and after staying there in UK some years, I managed to take asylum due to the threat to my life. However, my family members, she so and so and so and so, are there in Bangladesh in the mentioned address. I managed to obtain the UK so and so travel documents on 24th April 24 and I arrived in India on 25th March 2025 with a proper visa, India visa, and crossed over to Bangladesh illegally through unknown unfenced international border with the help of some person on the night of 1st July, while I, along with one more person, namely so and so, while crossing from Bangladesh to India via Dowki area, we were apprehended by BSF of India and handed us to police. After that, they integrated us in camp. It is a fact that I have crossed over to Bangladesh and returned to India illegally through unfenced international border. And Lordship will see the second accused also at page 16. He gives the same statement, Lordship.
So, that is what the basis of the case against you.
That is the only basis. And this statement, how it has been obtained, Lordship is very well aware how the Lordship, the police treat these suspected Bangladeshis.
This court is not at all aware. Court was never in police custody.
What
So
I am trying to say is that this cannot, Lordship, even assuming this to be wholly correct, cannot be a singular basis to charge me, Lordship.
This statement is not admissible in law.
Lordship.
Okay.
And
that is what your contention is,
Lordship,
it?
yes.
It's not the finding of the court.
Lordship, that is my contention, and this cannot be the singular basis to file a charge sheet, Lordship. Had it been a question of nationality, perhaps, Lordship, this would have been enough, because then
the trial court has taken cognizance of the matter.
Lordship, a charge sheet has been filed. Matter is for framing
But then
of
you have
charges.
not received any communication from this.
Lordship, no, not yet.
You have not been summoned to appear before it. No.
No, I have been summoned. Charges is yet to be framed, because charge sheet was filed 31st July, but this has just been put up recently, Lordship.
And when it is fixed for?
Lordship, I'll just.
It is not before 11th of September.
No, Lordship, no. And scope for discharge and all that is very limited in these kind of offences, Lordship. Because this 14A will be a sessions tribal case.
Scope for quashing is unlimited.
Lordship.
Yes, that is what I was about to say.
This will, if at all charges are framed, 14A is a sessions tribal case. So that will come to July. I will be a fresh summon will be issued. Case will be renumbered. It will be a long process, Lordship. If I have to. So my humble submission is, Lordship, that my first submission is, Lordship, that the allegation, the entire allegation,
yes,
is without any material basis whatsoever. And my second submission is, Lordship, that the burden of proof to prove an offence under 14A does not initially lie upon the accused. It does lie upon the state itself to show some material to shift that burden, Lordship. For
Burden of proof under
Section 9 does not apply for a case of alleged entry under 14A. It is only with confined to the issue of nationality.
any decision on that?
Lordship, yes, I just placed those.
Yes, please.
And lastly, Lordship, my humble submission is that the authorities, without any basis, cannot simply apprehend some person and make him face a trial under such stringent law without any basis. Especially when the charge sheet also does not have anything to show that what is the material collected in the investigation on the basis of which this charge sheet has been filed.
And that is covered by your first submission.
Lordship, yes.
Allegation is without any basis.
Lordship, yes.
Isn't it?
Lordship, yes. I am saying right from the very FIR.
Yes.
Yes.
So that is what?
Lordship, yes. So two submissions.
Allegation is also without any basis.
Two submissions. One is that the entire material collected through the investigation, right from the time of lodging of the FIR till the filing of the charge sheet, is without any basis to substantiate a charge under 14A. And second, Lordship, is that the burden does not lie on me. It is for the prosecution to prove the foundational facts, and they not having done so. Lordship.
Show us the decision which you are relying upon.
This is Rahim Ali Abdul.
Has it been reported anywhere, Mr.?
This is reported in the neutral citation, Lordship. I was trying to look in the SCC book. I could not get it, Lordship. This is neutral citation is there, 2024 INSC 511. This is a very lengthy judgment talking about lots of issues under the Foreigners Act, Lordship.
Yes.
If I may refer to certain paragraphs.
Yes, please.
Lordship may kindly see page 11 first. Para 15.
Para 15, page 6.
Page, this is page 11, internal page 11, paragraph 15.
Internal page 11.
Lordship.
Para 15.
Para 15. Learned counsel contended that the justification for placing the burden of proof upon the alleged foreigner has been dealt with by this court in Sarbananda Sonoval 1 Supra at para 26. I am trying to show what exactly is the burden of proof, Lordship. Now kindly see the footnote at down below. If I may read it, Lordship. There is good and sound reason for placing the burden of
that
proof.
speaks about another citation, another case.
Yes, this is
Sarbananda
Sarbananda.
Sonoval.
Yes,
So you do not have that decision with you.
I have put it in the book list, Lordship. Because I've just thought because this judgment covers all the aspects.
Instead of going through this decision, it is better for us to shift that to take up that other matter, isn't it?
Lordship can have that judgment.
The reference of which has been made here.
Very well, Lordship. But I am only relying on one paragraph of Sorbananda, which is covered in this judgment. That's why I thought to put this judgment. I have cited that Sorbananda case also.
Sarbananda case is reported when?
2005.
Yes, Sorbananda case is, Lordship. I have put a...
Okay, please proceed.
If I may just read it, Lordship, this footnote. There is good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country.
Yes.
In order to establish one's citizenship, normally he may be required to give evidence of his date of birth, place of birth, name of parents, their place of birth and citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under section 6A1D of the Citizenship Act. All of these factors would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. After he has given evidence on this point, the state authority can verify the facts and lead evidence in rebuttal if necessary. If the state authority dispute the claim of citizenship by a person and assert that he is a foreigner, it will not only be difficult but almost impossible for them to first lead evidence on the aforesaid points. This is in accordance with the underlying principle of section 106 of the Evidence Act, which says that when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him.
That is okay. You see, it is a justification why burden is proof is
Lordship.
on
So
the
what I am submitting, Lordship, it's there in the. I'll just come to that. Is that the allegation that I have illegally entered India, in this case, is not something which is in the knowledge of only the person concerned, because that allegation has to be the knowledge of the state who is prosecuting me, Lordship. That there is some information or knowledge or some material to show that I have illegally entered India.
See, the sum and substance of this paragraph is that there is no dispute about with your citizenship, isn't it?
Nationality.
It says, say supposing if there is a question of citizenship, then in such a case it will be impossible for the state
To prove it.
because state will not be holding any
Absolutely.
you see documents, any evidence in support.
Lordship, yes.
So that is why.
Lordship.
So here we are not concerned about your citizenship.
Lordship,
In
no,
this
what-
present matter.
What I am trying to
Isn't
submit
it?
is, Lordship, that the burden of proof under Section 9 is confined to that issue only, with regard to the issue of citizenship, not on the issue of any other issue, Lordship, such as overstay, violation, entry, etc.
This is Sarvana's case is only in relation to the dispute with regard to the citizenship.
NRC dispute, yes.
IMDT.
Yes, IMDT was struck down. And the
Claim of citizenship by a person.
Lordship, yes. So what I am only trying to submit is that Section 9 burden of proof is confined to that issue of citizenship, Lordship, not for an issue of allegation of
So, according to you, there will be no burden of proof
on me,
on you.
Lordship, because it is not a dispute of nationality.
So there is no direct decision on that.
Direct
Has to
decision,
be-
the reverse is there. So Lordship may kindly see internal page 36, para 34 of the same judgment. Of course, this is on nationality, but in my humble submission, the principle would apply, Lordship. Internal page 36, paragraph 34.
Yes.
However, the question is that does Section 9 of the Act empower the executive to pick a person at random, knock at his or her door, tell him or her that we suspect you of being a foreigner, and then rest easy basis on Section 9? Let us contextualize this to the facts at hand. The originating point of inquiry is the SP B Nalbari's direction to the SI Datta on so and so. The pleadings and the records are silent as to what was the basis of the SP B Nalbari's direction, what materials or information had come to his knowledge or possession that warranted his direction. Obviously, the state cannot proceed in such manner, neither can we as a court countenance such approach. First, it is for the authorities concerned to have in their knowledge or possession some material basis or information to suspect that a person is a foreigner and not an Indian. Even in the case of burden of proof, Lordship, with respect to nationality, the state cannot simply pick up someone and shift the entire thing on them. They have to have some material to substantiate the allegation, Lordship. And in this case also, at the end of the day, Lordship, the Honorable Supreme Court has set aside the proceedings under 14A against this particular petitioner. That was on nationality, but on the ground that they cannot simply shift it to them, and there is no material otherwise from that, apart from that, Lordship. And Lordship may also see paragraph 46, page 50 of the same judgment.
Page?
Internal page 50, para 46. it talks about Lordship fundamental rights also being applicable to these people.
Yes.
And notably, the Constitution of India, Part 3, distinguishes between citizens and non-citizens. Article 14, 20, 21, 22, 25 and 27 are available to all persons. We have kept in mind Articles 14 and 21 of the Constitution while penning down this judgment. In Mukesh Singh versus State, Narcotic Branch of Delhi, so-and-so, a bench of five learned judges held that now, insofar as the observation made by this court in para 13 of Mohanlal so-and-so, that in the nature of reverse burden of proof, the onus will lie on the prosecution to demonstrate on the face of it that the investigation was fair, judicious, with no circumstance that may raise any doubt about its veracity. Is to be noted that the presumption under the Act is against the accused. This was under NDPS, but the principal, Lordship, is very much there that the onus will lie in the prosecution that investigation is done fair and some material basis is there to substantiate the charge, Lordship. Which is, in my humble submission, in the instant case, it's not there at all, Lordship. Simply by reproducing the FIR and putting that charge sheet, Lordship.
Now, question of honors and all those things.
Lordship.
Is it not? It comes at the stage of trial.
It does, Lordship, but my humble submission is that on what basis? They cannot, the state, Lordship.
Now, these decisions which you have referred, especially this observation in Mukesh Singh case and all.
Lordship.
Is it not that all those came after the trial was held?
That is, of course.
Somebody was
yes.
convicted or
Correct,
punished,
correct.
isn't it?
No dispute with that, Lordship. But I am only suggesting that even at the stage of quashing, Lordship, some case has to be made out by the prosecution. They cannot simply say that the entire burden lies on you, so we cannot, it cannot be quashed at all. You prove in the trial. Some basis, some material basis in the investigation to show that yes, then only, Lordship, I should be charged. Because burden of proof will come once I am charged. Now, how I am charged in this case, Lordship, is entirely unsubstantiated.
That is your own statement, isn't it?
On my own statement. Nothing to show that someone saw me, someone caught me in the act, or anything, Lordship. Vague allegation that I have illegally entered from the unfenced border and I was apprehended by the BSF. Where I was apprehended? In the market, Lordship. And this was having a serious impact to the entire, Lordship, if I may so say, the future of the petitioner, Lordship. Because now, in the event the trial goes on, Lordship, and if he is acquitted at the end of the day, even then a problem will lie as to, because he will be rendered stateless.
No.
Then again the issue of...
Why?
No, then the issue of overstay will come. Then he has to again go and get an extension of the visa.
If his overstay is because of some wrong action of the state,
Lordship, yes.
then that state will have to correct it.
Correct, but that will be another, Lordship,
But then he will be made to suffer.
Yes, some difficult, it is not that easy process that I'll just go take the flight and... So what I'm only submitting, Lordship, that in this kind of a case, Lordship, the prosecution should be a little more aware before charging a person, because this is having serious impact through to his entire life, Lordship, and this involves aspects of international law, basic human rights. So my humble submission is, Lordship, in the facts and circumstances, considering that there is absolutely no material in my humble submission to substantiate the charge, Lordship, it is clearly an abuse of process of the law and the case may be quashed, Lordship.
Yes.
That is my preliminary submission, Lordship. Subject.
Both the cases, same submission?
Same submission, Lordship.
What is your
I'll just point out the
validity of visa and all in the other case?
I'll just point out the differences in the next item, Lordship. Criminal petition 51.
Yes.
It is the same. Passport is issued by the same authority, UK passport.
Yes.
So no difference with that. Only difference.
Some situation are same.
Same. Only difference being visa is expiring in 2nd December there. So another 3
What
months'
is the
time.
visa issued on which date?
This visa issued on 3rd June.
3625.
3625 expiring on 2/12/25. I entered on 5th June 25. That is the only difference. And thereafter it is all the common affair, common 2nd December of the second person.
2/12/2025. Yes.
Lordship, yes. That is for the second petition.
Yes. Madam.
Yeah. May it please your Lordship?
Yes.
Your Lordship, it is not a disputed question that the petitioner is not a Bangladeshi nationality. That is not in dispute here, Your Lordship. He was a Bangladeshi national. He had gone to UK on account of the threat on his life. He has sought asylum in UK and has obtained a passport, UK passport of the United Kingdom, Your Lordship. Now, Your Lordship, may kindly see this. It's not very legible, Your Lordship. The extra one, which is the passport issued by the United Kingdom, it says that he can go anywhere except Bangladesh. On the basis of this passport, Your Lordship, he has applied for a visa to visit India. And the Indian government has given him a visa, Your Lordship. And the first Mahtab Uddin, that is in criminal petition number 50, he has obtained a tourist visa, Your Lordship. The second one, which is criminal petition 51, he has obtained a medical visa, Your Lordship. So there is a difference, which is why I think the date of expiry of both the visas are also different. Now, Your Lordship, here he has obtained a tourist visa on the basis of the passport which was issued by the government of the United Kingdom, and he has travelled to India and entered India through New Delhi on 21st March 2025, Your Lordship. Now, Your Lordship, he has come to Dauki when we do not know, Your Lordship, but he was found on 1st of July 2025, 300 meters away from the international pillar or whatever you call that border, Your Lordship, when he was waiting for taxi late at night at 10:30 p.m., Your Lordship. Now, the intent of this person, Your Lordship, appears to be that at 10:30 at night in Dauki area near the international border, Your Lordship, he was found waiting for a taxi. Now, Your Lordship, the border security force...
That was in violation of law.
So, he had entered. Because he had entered...
That is your allegation. But
yes, Your Lordship. No, we will have to be given the chance to satisfy that also, Your Lordship.
Definitely, you are saying.
Yes. Now, Your Lordship, after he has entered, when the BSF, Your Lordship, the Border Security Force, the primary responsibility of the BSF people is to secure and guard the international borders, Your Lordship. This BSF security, Your Lordship, which was patrolling at that hour, Your Lordship, in the border, Your Lordship, had received specific information. It is not that we have just picked them up.
That is what the FIR says.
That's what the FIR says, Your Lordship. And he says that on receiving specific information of Unit G Cell, patrolling party of BOP, Border Outpost Dauki, consisting of ASI JP Singh, along with 3 SOs and 1 OR, total 5 personals, apprehended 2 UK national suspected to be Bangladesh nationals in Dauki market area. During preliminary questioning, the BD national revealed their names as Mahtab Uddin and Zia Rahman. Both were in possession of UK passport, and during preliminary questioning, they revealed that they came to India for visit purpose only and further illegally crossed over to Bangladesh to meet their families. BSF party apprehended them when they crossed over to India from Bangladesh. That was when they were crossing to India from Bangladesh and were in search of transportation from Dauki to Shillong. Then, Your Lordship, these are the details of the apprehended person which is given in the FIR, including the items recovered from their possession. And in the next page, Your Lordship, the place of occurrence, date and time, 1/7/2025 at 22:30 hours. That means at
That is
10:30 p.m.,
you are
Your
referring
Lordship.
to page.
Next page of the FIR, Your Lordship, at page 22. At page 22 of the criminal petition, Your Lordship.
Yes, yes, yes. Yes.
Yes. Now, Your Lordship, date and time is 1/7/25. The place of occurrence at about 22:30 hours, which is 10:30 p.m. Place of seizure in the alignment of BP number 1273. Then type of seizure, incoming. They were incoming, Your Lordship. Claimed, unfenced. They were coming through an unfenced border. And the distance from the international border is approximately 300 meters. And the rest is there, Your Lordship. Now, who are the details of the BSF party has also been given, Your Lordship, in the FIR. The details of the BSF party who had conducted the arrest has also been given. Now, on being arrested, they were handed over to the state police, Your Lordship, at Dauki. And then the investigation, they were produced before the magistrate at Amlarem. They have been released on bail on July 2025, Your Lordship. Now, Your Lordship, in the criminal petition, it is an admitted position, Your Lordship, at page 8 of the criminal petition, para 3, that the condition of the passport, document of voyage, the petitioner is entitled to travel to all countries except Bangladesh. It's an admitted position, Your Lordship.
Oh, yes, okay.
Yes. Except Bangladesh, they were not allowed to go. I mean, they were allowed to go anywhere except Bangladesh. Then, according to the strength of the set...
If they go to Bangladesh, that is not a violation of Indian law, isn't it?
Your Lordship, but the very fact that... But they have entered India.
So that is what?
They have entered... They stayed in Bangladesh for several days.
Your allegation of illegality...
They have entry.
Yes.
The entry. Because, Your Lordship, whenever any foreigner visits India, they have a designated point of entry and exit, Your Lordship. And they have to do that from there. But here, their exit from India through an unfenced border in itself is a crime. And then they have, after staying there for several days, visiting their family, they have come back to India through an unfenced border, Your Lordship, which is not a designated entry point, Your Lordship.
When did they enter the Bangladesh?
They entered, that is, I think the BSF...
But then you said that they have entered and they stayed for some days.
Yes, that is what we have come to learn.
From when to when?
We have come to learn that they spent about 20 days in Bangladesh, Your Lordship.
Where is that allegation mentioned?
It is not with us, it is if Your Lordship goes through the affidavit filed by the respondent number 2, Your Lordship will find
There is an
that.
affidavit filed by respondent number 2.
Yes, they have filed one affidavit today. Objection, there is an objection affidavit for the quashing of the criminal proceedings before Your Lordship.
Okay.
Now, Your Lordship, their main concern is that they are going to be castigated, there will be a big impact on their future if this case is not quashed here and now, because they have to leave India before the expiry of the visa, Your Lordship. But, Your Lordship, I just want to pause here for a moment and say, Your Lordship, that how can they think only of themselves? Now, the very fact that they have violated the visa condition, entered India through Bangladesh, is of national concern.
Sympathy is not a consideration for
Yes, yes, and
what
that, Your
happens to
Lordship,
their
the
future?
security of our nation is at stake.
Our concern is with regard to the law and violation.
Yes, Your Lordship, because they have also stated in their petition, Your Lordship, that this is just a crime that involves only the individual, but not the society. But is it not a crime that involves the entire nation, Your Lordship? That is also one consideration aspect that Your Lordship will have to take into consideration at the time of considering their petition for quashing the criminal proceedings, because it is the security of the nation that is at stake when these people illegally cross the borders. And then they blame the country for having made false allegations against them, Your Lordship. Now, Your Lordship, In this case, Your Lordship, then they have filed a charge sheet. The police have filed a charge sheet, and
Whether the accused has offered any explanation as to why he was in Dowki?
they have offered that. Oh, in Dowki, Your Lordship, they have come to Dowki to visit their family in Bangladesh.
No.
They visit their family in Bangladesh.
No. Otherwise, in the present case, is there any averment in the petition where they say the purpose of visiting?
Visit to Dowki, Your Lordship. That they have not specifically said anything,
Okay.
Your Lordship. That they have come to Dowki. Maybe they have just said that we were in and around the Dowki market searching for her vehicle to come back to Shillong, and to their utter shock and surprise, they were apprehended by the BSF personnel. Now, Your Lordship, the charge sheet, my friend has been saying that there are only 2 statements of the accused persons where they have implicated themselves.
There is no other statement of those BSF.
They are there. It is there, Your Lordship, but it has not been attached with the charge sheet filed by my friend. But the charge sheet which we received from the police, Your Lordship, there it is. All the BSF personnel have been examined, and they have stated the same thing.
They have given me a charge sheet with a list of enclosures marked to 1 to 13. This is all I have.
But here we have
Something
received.
which is in the record, which is not given to me, I do not have it.
It has to be very much.
The BSF,
that is the case,
those people, the BSF personnel
Wait, just madam, let us just verify the list of documents.
Kindly see page 14 of my additional affidavit.
There are 13 documents.
13 documents.
Enclosure. So we cannot say that there is anything more than that.
Lordship, I have not, and my statement is mentioned. There was no reason for them not to enclose the complainants or any other witness statement.
Yes, enclosures is 13.
Lordship, yes.
Where is it?
Yes.
Page 14 of the affidavit.
Do you want to say this page 14 is forged, Madam Yankee?
Your Lordship, I'm just going to it.
Sealed by the magistrate.
Who knows? Let us see. It speaks about 13 documents.
Yeah, 13 documents,
So
Your
go
Lordship.
by 13 documents.
But here, Your Lordship, what we have received from the government shows that the BSF has also been examined, and they've given a clear statement
We
that.
do not know. We go by what has been supplied to the court. What you have received from the government, that is not our concern.
Be that as it may, Your Lordship, if Your Lordship is not going through the BSF documents, statements.
There is no question. We are
Yes,
concerned
Your
with the
Lordship.
documents which are before the court.
Yes, Your Lordship, I would just like to bring to Your Lordship that the FIR discloses an offence against these 2 accused persons, Your Lordship. Offence of illegal entry into India through Bangladesh through an unfenced border. And that in itself, Your Lordship, is sufficient to not to allow the quashing of this FIR or the criminal proceedings, Your Lordship. Lordship, we have, in fact, there are some citations, Your Lordship, where once the charge sheet has been filed and the FIR is there, discloses the offence, Your Lordship, then I am referring to.
This is known, madam. You do not know. Right from Bhajanlal it says, if there are allegation.
Yes, Your Lordship.
If FIR discloses an allegation, then definitely.
Yes,
there
Your
is no
Lordship.
question.
And here the allegation is disclosed, Your Lordship.
That is what you are saying.
Because this was a report received from the intelligence cell. It was not like my friend had said that we picked up these 2 petitioners from the market area just because they were found loitering there. It was not that, Your Lordship. That is our report from the intelligence, and we have used that because it is important. And Your Lordship, it says that once there is some evidence, Your Lordship, or indication.
So you suspect them to be agent of some.
That is not on record, so I cannot say what I suspect and what the BSF suspects, Your Lordship. We are only concerned that they have made an entry through a entry point which was not designated for them, Your Lordship. They were allowed to come to India, but then they were not allowed to go to Bangladesh and then come back from Bangladesh to India, Your Lordship. So, Your Lordship, We, the state, Your Lordship, we pray that we may be allowed to prove our case, Your Lordship. If Your Lordship quashes this case at this stage, Your Lordship, then great injustice will be done, Your Lordship, because these such things will be repeated again, Your Lordship. And my citation, Your Lordship, if Your Lordship doesn't...
If you want, you can give. There is no problem.
Yes, because it says that, Your Lordship, where allegations break out ingredients of charges leveled and material placed before the court.
Please pass it.
Pass it off.
Yes. Which paragraph?
Your Lordship, I would like to take Your Lordship to this page 332.
Paragraph?
332, paragraph is not, it is just shown as paras 25 to 28.
You are reading the head notes. You come to the.
No, paragraph 25 to 28, Your Lordship. At page 332, I just want to show you.
No, you are. Let us come to the main part. Let us come to the main
you
part.
want, Your Lordship.
It is just like reading index, you see. Come to the main part.
Index is a summary also, Your Lordship. Now, page 25, para 25, section 482
Yes.
CRPC is being extracted here under. 482, saving of inherent powers of High Court. Nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order.
You can leave this part. First
Yes,
paragraph
Your
is my
Lordship.
procedure.
Then this court has an occasion to examine the matter of state of Orissa, so and so, which was heavily relied upon. Now, regarding the argument of the accused having to face the trial despite being in a position to produce material of unimpeachable character of sterling quality, the width of the powers of the High Court under Section 482 of the Code and Article 226 of the Constitution of India is unlimited, whereunder, in the interest of justice, the High Court can make such orders as may be necessary to prevent abuse of the process of any court or otherwise to secure the ends of justice within the parameters laid down in Bhajanlal case. Recently, this court again had on an occasion to examine the ambit and scope of 482 CRPC in Rukmini Narvikar versus Vijaya Satyaderkar. High Court under Section 226 was in the said judgment, this court held that the High Court could make such orders as may be necessary to prevent. In a concurring separate order passed in the same case, it was additionally observed that under 482, the High Court was free to consider even material that may be produced on behalf of the accused to arrive at a decision whether the charge, as framed, could be maintained. The aforesaid parameters shall be kept in mind while we examine whether the High Court ought to have exercised its inherent jurisdiction under Section 482 in the facts and circumstances of the case. The High Court, in exercise of its jurisdiction
These are all
under
general propositions. There is no
482 must make a just and rightful choice. This is not a stage of evaluating the truthfulness or otherwise. This is what I wanted to emphasize on Your Lordship, that at this stage, Your Lordship, it is not the time of evaluating the truthfulness or otherwise of the allegations leveled by the prosecution complainant against the accused. Likewise, it is not a stage for determining how weighty the defenses raised on behalf of the accuser. Even if the accused is successful in showing some suspicion or doubt in the allegations leveled by the prosecution complainant, it would be impermissible to discharge the accused before trial. This is so because it would result in giving finality to the accusations leveled by the prosecution complainant without allowing the prosecution or the complainant to adduce evidence to substantiate the same. The converse is, however, not true, because even if trial is proceeded by the accused is not subjected to any irreparable consequences, the accused would still be in a position to succeed by establishing his defenses by producing evidence in accordance with law. There is an endless list of judgments. So this is what I wanted to emphasize on, Your Lordship, that at this stage, Your Lordship may not weigh the defenses or the allegations made by the truthfulness of the allegations made by the prosecution, Your Lordship. Once a charge sheet has been filed, Your Lordship, it would be in their interest and in the appropriate, Your Lordship, rather, that they face the trial, Your Lordship, and if they think that they have a good case, then they can always pray for discharge under 227 of the CRPC, Your Lordship. But at this stage, Your Lordship, my prayer is that the case may not be quashed. The very only because of the reason that their visa is going to expire, Lordship, that cannot be a ground for allowing them to go scot-free, Your Lordship, after having committed a crime and denying us the right to prove our case, Your Lordship. That is one of them, Your Lordship, and that is my prayer, Lordship.
Yes.
That under 227, Your Lordship, it says that once the charge sheet is filed, then the proper remedy of the accused in such a case would be to discharge, to relegation to discharge application under 227 CRPC when warranted. I'll just give this also, Your Lordship. Here. And there's overstay can be regularized, Your Lordship. If the competent authorities are directed, it can always be regularized. There's an authority that...
This one paragraph, which paragraph you are referring? Iqbal.
This paragraph 6 to 12, Your Lordship. Iqbal Alias Bala and others, 6 to 12.
Yes. You appeared for respondent number 1.
I appeared for 1, Your Lordship.
Yes, Dr. Mojik, how long you are likely to take?
Just 5 minutes, sir.
Okay.
Within 10 minutes, sir.
You are respondent number 2.
Well,
Yes.
my lord, it appears he has been charge sheeted for one offence, my lord, but it appears they have committed multiple offences, my lord. Maybe supplementary charge sheet will come. Lord, kindly turns to page 20, my lord, of the petition.
Page 21.
20. This is a visa. Second case is 51 or 50?
Yes.
Lordship is petition number 50.
Page 20 is. Fast. Yes, criminal petition 20.
50.
Sorry, 50.
My lordship kindly sees, though there is a seal and we cannot read it properly, but I've deciphered what is there. There are 3 conditions laid down in the visa, my lord.
Cannot make out from here. It's not possible.
But I found out, my lord. First condition is permitted for single stay not exceeding 30 days. First one, my lord.
Okay. But
Online
then
I
it
checked
is-
other visas also,
this
my lord.
court is-
My lords.
It is. You do not know how you are reading it. It is impossible.
My lord, what I did, I compared both the visas, my lord, in the other petition 51.
For you it is okay, but then for this court you cannot examine this way. Yes, Mr. Dev, if it is not visible, then it is a problem. If it has some material bearing, then it's a problem.
In fact, this is the standard conditions. What sir is saying is correct. That permitted for single stay, not
Exceeding 30 days.
30 days. These are the standard conditions, Lordship.
That's one, first, my lord. Second is not valid for prohibited, restricted cantonment areas. That's the second condition, my lord. And third condition is there would be a gap of 2 months between 2 successive visits. Now, my lord, here is a case.
Both the visa same condition.
Both the visas same condition, my lord. Here they've entered. I will just refer to their date of entry, my lord. Just see. Which 50. Now he entered on 25th of March. Apprehended in the month of July, my lord. So he has already violated first condition that his single stay will not exceed 30 days.
What is meant by single stay?
Single stay is once he comes, my lord, he has to go back within 30 days. Then he can come back again.
What about the validity of visa then?
Visa is valid for validity of visa is 6 months, my lord.
Okay. But then he cannot stay more than 30 days at a stretch.
At a stretch cannot. Because that's what is a usual thing, my lord. Even US visas, we see, my lord, visa is granted for 10 years.
Achha, okay, let us see. 5 minutes.
Some meeting.
There's a meeting. So,
Continue tomorrow. Continue tomorrow.
well, so you can have another 5 minutes probably.
I'll conclude in 5 minutes. I have a small submission to conclude. That's one part.
No,
my
but
lord.
then see, you see, it is not that you make a submission. The court must get it. You see, first of all, the conditions which you are showing, it is not visible here. Now, this is one difficulty for this court.
So, my lord, what we can do, I can type it out, my lord, and place it.
That is not your responsibility. It is his responsibility, basically.
There is no dispute with that 3 conditions with.
But then I must know what is the condition. It is not visible.
I'll put a lordship a clearer visa with the.
We'll continue tomorrow. That is
Tomorrow.
better.
Place and typing, my lord.
I had done it counsel for the parties. Stop. The hearing remained inconclusive. List just tomorrow for further hearing. If tomorrow's meeting.
Actually, what happened, my lord, his visa from UK says that he cannot travel to Bangladesh.
You cannot travel to?
He cannot travel to Bangladesh.
Passport.
His passport from which has been issued to UK because he is on asylum to UK, my lord, from Bangladesh, and the passport says that he cannot go to Bangladesh, my lord.
Yes, that is.
So what he does, my lord, he comes.
That
to
has
India.
been submitted by Mr. Deb.
So his intention is to come to India, then from here go through the border. my lord.
See, many things we can presume, but then
that's the fact, my lord.
law is supreme, isn't it?
That's the fact.
Whatever we say, that must be borne by the materials on record.
Yes. No, that is not material, my lord. His passport says that he cannot travel to Bangladesh.
Yes. But then whether he has gone to Bangladesh or not, and whether you have caught him.
My lord, he is a UK citizen for last 15-20 years. Why Bangladesh Taka is in his position, my lord?
That may be a
He has
different
to
issue.
explain, my lord, in trial. That's all.
That may be
I
altogether
don't have
different.
Bangladesh Taka in my pocket, my lord. How he
Let
gets.
us see whether you make out a case under 14A or not. That is what we'll just. Right now, we are not going into any other.
Restricted area. There are rules for that one.
Okay.
Tomorrow.
Yes, tomorrow. Yes.
My lord, so far item number 12 is concerned, my lord.
So just a minute. Two and 3 both are same order. Just give it the answer. 2 and 3 same order, is it? Yes.
Lordship.
My lord, so for the item number 12 is, I'm sorry, my lord.
Yes.
I'm sorry, item number 12 is concerned. May I pray that the matter may be fixed on 9th or 10th, 9th of September.
Item.
12, my lord.
You are appearing for?
From the petition.
New counsel.
Huh?
Earlier, Mr. Sudhir.
Petition.
Maybe my friend is telling.
But now senior would be the purpose of hearing, he would be leading us in this case. This is first appearance.
Okay.
May come up after 2 weeks, my lord. There is no urgency as such.
He's requesting for a date now.
Date, you just take it later because we do not know. There may be change in the situation after this week. You are very much
Correct.
well aware. So we'll just list it after 1 week or 2 week, whatever.
After 2 weeks, my lord.
Yes. Yes, Mr. Mr. Senior Counsel. When do you want it?
On 9th or 10th as of
See, we cannot give you a fixed date as of now. There may be a change in situation after this, but then we can give you after 1 week or 2 week, whatever you say. We will not fix it on date.
1 week, my lord. After a week.
After 1 week.
There's no urgency, my lord. In fact, 2 weeks would be.
2 weeks. Yes. Is it all right with you? 2 weeks. The other side wants it after 2 weeks.
My lord, this trial court is going on. Trial is going on. There is no interim order. Only thing, my lord.
See, all along this matter was adjourned at your instance.
My lord, That I know, my lord.
That is what.
Adjourned.
We'll just we'll have it.
Today
couple of
also
weeks.
we are ready for hearing, my lord. Today also we are ready for hearing, but unfortunately the matter has not been because of the paucity of time, my lord. My lord, so therefore I request, my lord, I pray before your honor, lordship, my lord, to fix the
See,
matter after which.
after 1 week it appears the other side has difficulty. Okay. So we'll have it after 2 weeks. If you have any difficulty, your juniors are here, they will see it. Okay?
Okay, my lord.
Item 12.
Yes.
What is list after 2 weeks?
Obliged.
Yes.
Lordship, item number 19, I'm praying if the matter can come up after a week, my lord, or 2 weeks. My lord.
Who is there in 19?
Yes, Mr. Pandit.
Yes.
This is for quashing, my lord, arising out of an accident. So they were
There is a
supposed to
compromise.
take, yes, my lord. So on the last occasion, the complainant, who is a police officer, your lordship was pleased to ask direction from the instruction from the concerned complainant. So he is supposed to give the what was the
Complainant is
instruction.
appearing through a counsel.
Yes.
Huh? Anyway, yes.
Next week, my lord.
Hmm?
Next week.
After a week. 19 also. Prayer of the matter reservation after a week. Yes. Madam, number 14 matter. I'm praying for 2 weeks. Who is the other side? No, no problem. This also 2 weeks after.
Item number 13, lordship. 1 week, lordship. Item number
Which
13.
one?
1 week, lordship.
Which one?
Item number 13, 1-3.
Yes. We try to yes, this also 1 thing after a week.
Not after a week, Your Lordship, after 2 weeks.
All right.
After 2 weeks. Okay, make it after 2 weeks. Yes. Any matters remaining for?
Item number 15, Your Lordship.
Yes.
Praying for 2 weeks, Your Lordship.
No problem. 15 also 2 weeks on prayer bodies. Yes.
Obliged, Your Lordship.